Hi, everyone. My name is Melissa Martin, and welcome to this CLE course presentation entitled Fundamental Rights to a Clean, Safe, and Healthy Environment, the Case for Green Amendments. I'm joined by my colleague, Maya Van Rossum, who you'll hear from in just a minute. But we thought it was important to provide timely legal insight and analysis regarding an emerging and necessary intersection between environmental law and constitutional law, which probably should stir the interest and attention of anyone working in the field of public interest environmental law and advocacy. So we'll be reserving time at the end of our presentation here to answer any questions you might have, and we'll also be providing our contact information later on. So if you have any questions or comments afterwards, you can reach us. So for now, let's take a look at our agenda of basic learning objectives today. So here is Maya.
Yeah, so thanks very much, everybody, for joining us. We've got a pretty direct agenda. We're going to talk about why green amendments are necessary. Of course, during the course of our conversation today, we will actually explain and define what a green amendment actually is. A green amendment is a certain type of constitutional environmental rights amendment that lifts up environmental rights to their highest constitutional and legal standing. That's the short definition. We're going to talk about why green amendments of this kind are necessary, how green amendments can bring change, and how to enact green amendments in your state. So with that, I'm going to turn it back to Mo.
So a couple quick intros. Once again, my name is Melissa Martin. I'm a Florida attorney and have been volunteering in support of the Florida Right to Clean Water Citizens Initiative. I'm a native Floridian with a career as a Marine Corps judge advocate. And so after retiring in 2014, I almost immediately became active in my community on issues of good governance, clean water, and conservation. So I did what I could on various fronts and in diverse capacities, to include teaching a couple of classes at Barry University School of Law as an adjunct law professor in water pollution law and environmental ethics. So now I have the honor of introducing Maya Van Rossum, who I've had the pleasure of knowing since last year when we realized we were on parallel tracks toward fundamental, enforceable, self-executing environmental rights. So Maya.
So for the last 30 years, I've had the honor of serving as the Delaware Riverkeeper and leader of a 4-state advocacy and litigation organization called the Delaware Riverkeeper Network. But during my work and journey, serving as the Delaware Riverkeeper, a role that I still function in to this moment, to this day, I also have experienced how our current system of environmental protection laws fundamentally fail us, and identified a new pathway for protection, which is the Green Amendment pathway that we're going to be talking about today. As a result of those realizations and recognitions, I founded a new national movement and organization called Green Amendments for the Generations. And one of the tools I've used to spread the Green Amendment message is a book that I have written. There are actually 2 editions of it now. The second edition just came out in November of 2021, called The Green Amendment, The People's Fight for a Clean, Safe, and Healthy Environment. So why are green amendments necessary? They are necessary because our current system of environmental protection laws literally, fundamentally fails us. We have hundreds of thousands of environmental protection laws. We have agencies and policies and programs. But the way these laws are written, they are really written in a way that is focused on legalizing environmental pollution, degradation, and harm, not preventing harm in the first instance. And so as a result, we can just look across our nation and see how many communities are being impacted by environmental pollution, degradation, and desecration. And of course, environmental racism is literally built in to this system of laws. A constitutional green amendment fundamentally changes that. Green amendments are placed in the Bill of Rights section of our state and federal constitutions. They are self-executing, and they place environmental rights on par with those other fundamental rights. And as a result, they help bring transformational change. We know that we don't have the right protections in place under the current system of laws we have right now, because we can, in fact, look at what's happening on the ground with people being so deeply impacted by environmental degradation, again, environmental racism, and of course, we're facing a climate crisis. And so we know that we need a new pathway forward.
So let's take a look at what all is wrong with the world. As many of us know, despite compelling flowery language and goals and objectives in state constitutional provisions, the functional reality is that our laws are designed to regulate pollution, not prevent it. So, for example, the Clean Water Act, whose amendments were signed into law in 1972 and amended many times since then, still today contains the following language in its very first paragraph, which I always got a kick out of when I taught this course. A, national goals for achievement of objective. The objective of this chapter is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. In order to achieve this objective, it is hereby declared that, consistent with the provisions of this chapter, 1, it is the national goal that the discharge of pollutants into the navigable waters be eliminated by 1985. 2, it is the national goal that, wherever attainable, an interim goal of water quality, which provides for the protection and propagation of fish, shellfish, and wildlife, and provides for recreation in and on the water, be achieved by July 1st, 1983. 3, it is the national policy that the discharge of toxic pollutants in toxic amounts be prohibited. Not sure if you know this, but it is 2023, more than 50 years after the Clean Water Act became law, and pollutant discharge continues. Poor water quality that affects aquatic life and recreation continues. Toxic pollutants in toxic amounts continue. Not nearly as bad as they were before, but it's apparent that the system has failed its own objectives. So let's take a look at why. For one thing, gaps and well-designed loopholes in law perforate the body of law that is environmental protection. The system shifts the risk and burden of toxic collateral damages into areas of historically vulnerable populations, as I had noted before. The term for such areas is, I believe Maya had coined the sacrifice zones, environmental sacrifice zones, because these communities rarely have the ability to defend themselves from large corporations and their legal teams. So from the system's perspective, these communities will simply just get sick and die. And why? Because polluters want to continue what they're doing. Even if these communities were able to lawyer up, the laws themselves often create insurmountable obstacles. For one, in some states, agencies have the power to interpret and define standards of material terms, such as what the public interest means, or what is harm, or what is health. And if such states have enabled special interests to politically influence those interpretations, then interpretations will most likely favor those special interests over the health and safety of people or other life or economic interests dependent on a clean environment. So you'll also see problems of standing in many cases, and cases where courts will automatically side with agency interpretations because they're presumed to be right and just and serving the public interest. But the law can be too blind to the reality that special interests have the heavy influence they have on policies and regulation, enforcement, and sometimes legislation. So, and how bad things can get. Yet all of this is currently well within the confines of current law. So Maya is going to provide you such an example from her experience.
And so, and let's be clear, right? All the fundamental failings that Mel just talked about, do proliferate in every single state across our nation and throughout federal law. And so the kinds of harms and problems that we're talking about are nationwide. Now, but, as the Delaware Riverkeeper, I have over my career primarily focused on the 4 states of the Delaware River watershed: New York, New Jersey, Pennsylvania, and Delaware. And amongst the issues that I have been battling against in that role is battling against fracking, right? Fighting to protect our communities and our environments, to protect them from the ravages of fracking for gas from shale. It is sort of against the backdrop, not sort of, it is against the backdrop of the way the law operates that Mel just talked about that I have taken on that work. And I just want to focus on one of the watershed states, the Commonwealth of Pennsylvania, which is really where much of my time and attention has been focused over the years when it's come to the fracking industry. And it really is, as a result of the story I'm about to tell, it really is where the Green Amendment movement, at least as far as I'm concerned, where the Green Amendment movement really started. So fracking for gas from shale actually came to the Commonwealth of Pennsylvania in about the mid-2000s. And when it came to Pennsylvania, given the state of the law at the state level and at the federal level, it was really very easy for the fracking industry to proliferate across the Commonwealth of Pennsylvania, bringing with it, right, all of its highly polluting industrial operations, their 24/7 noise, light, and pollution, bringing with it contamination of our rivers, our streams, our groundwater supplies, even people's drinking water supplies, bringing with it the release of air pollution of all kinds, including climate-changing methane emissions, bringing with it the desecration and the devastation of our natural landscapes, the destruction of forests and wetlands and ecosystems of all kinds, and really subjecting Pennsylvania communities to the direct ravages and impacts of fracking. Bringing adverse impacts and harms to every aspect of the lives of the people of Pennsylvania. And again, given the state of the law, it was pretty easy for the frackers to do what they wanted, where they wanted. But the way I describe it, for the frackers, they felt that it wasn't easy enough. They wanted to find a way to make it even easier for themselves to be able to have their way with Pennsylvania's communities and Pennsylvania's environment in order to continue to perpetuate the fracking industry and make the increasing profits that they were so eagerly seeking. And so in 2012, actually starting in 2011, but finalizing in 2012, very literally, leaders from the fracking industry got together and went behind closed doors. And behind those closed doors, they put together a piece of legislation that was actually passed by the Pennsylvania legislature and signed by then Pennsylvania Governor Corbett into law. And when this law was passed, it came to be known as Act 13. Now, Act 13 had a lot of elements, but literally when you looked at it writ large, it was literally a gift basket to the industry. And, as I say, of course it was a gift basket to the industry. The industry wrote it for themselves, right? So they wanted to pack it with as many gifts as they could, and they were very successful at that. And so Act 13 did a lot of bad things when it came to fracking and really made it easier for this devastating industry to advance. By way of example of the kinds of provisions that Act 13 included that would allow this industry to advance in serious and devastating ways, it preempted local zoning authority. And so while municipalities could zone where within their communities their highly polluting industrial operations like fracking would need to be located, when it came to fracking, that authority was preempted by this state law. And very literally, drilling and operating fracking well pads had to be allowed to operate in every part of every community in the Commonwealth of Pennsylvania, in their agricultural districts, in their historic preservation zones, in their environmental protection areas, and in the heart of their residential communities. With drilling and operating fracking well pads, by virtue of state law being mandated to be allowed to be located as close as 300 feet from people's homes, from schools, from playgrounds, from hospitals. That's less than a football field. That's really darn close. It put in place automatic waivers from a number of environmental protection standards that would apply to every other industry, but now would not apply to fracking. It alleviated the frackers of the obligation to notify those who are on private drinking water wells that their drinking water had become potentially contaminated by nearby fracking operations. And it did more. And so the fact of the matter is, while fracking was already overwhelming Pennsylvania's communities and Pennsylvania's environments, if Act 13 was allowed to go into play the way it had been written, things would have gotten exponentially worse for the people of Pennsylvania, because there would have been an exponential expansion of the fracking industry and its very heavy boot print on Pennsylvania's communities and natural landscapes. Now, at the Delaware Riverkeeper Network, we do advocacy and activism and grassroots organizing, but amongst the things we do is we litigate. We litigate when necessary to protect our environments and to protect our communities. And so we knew that we had to find a way to challenge this Act 13 and stop it from inflicting its devastating consequences before they could even start. And so we were thinking, what would be our legal strategy? And by the way, 7 municipalities joined us in our litigation, and they brought with them a set of really important legal arguments to what became now this joint venture. But the legal arguments that the Delaware Riverkeeper Network, through our attorneys, brought to this effort was, we argued, amongst other things, that Act 13 would violate a long ignored constitutional environmental rights amendment that had been placed in the Pennsylvania Bill of Rights back in 1971 and recognized and protected the rights of all Pennsylvanians to pure water, clean air, and a healthy environment, and the duty of all Pennsylvania government officials to protect the state's natural resources for present and future generations. The thing is, while this constitutional language had been added to the Pennsylvania Bill of Rights back in 1971, there were some really poor case choices that had been brought early on. And long story short, the Pennsylvania courts declared this constitutional environmental entitlement to be just a statement of policy, and really robbed it of all of its legal strength very early on. In fact, the Pennsylvania Supreme Court Chief Justice at the time said with one of these early decisions that the majority opinion had disemboweled the Pennsylvania Environmental Rights Amendment. Very, very strong language. And so literally for 42 years, there was this powerful language in the Pennsylvania Constitution, but legally nothing had changed on the grounds for the people of Pennsylvania and its environments. But we at the Delaware Riverkeeper Network thought that this Act 13 was such an incredible overreach and was going to have such obvious, devastating consequences that maybe we could get the Pennsylvania courts to reconsider that 42 years of bad precedent and set things right. And long story short, our challenge to Act 13 did go all the way up to the Pennsylvania Supreme Court, a very conservative Supreme Court at the time, led by a very conservative Chief Justice. And in December of 2013, we got a powerful victory with the plurality opinion actually written by that conservative Chief Justice. A lot of people say if you want to fall asleep, right, read a Supreme Court case, whether it's state or federal, and you'll go right to sleep. Well, if you care about the environment, you care about our communities, you care about environmental justice, I will say read this opinion. And you will be wide awake and salivating for hours, because it is such a powerful opinion that is so beautifully written by Chief Justice Ronald Castile. But I just want to read a few quotes from Chief Justice Castile's decision that issued in December of 2013 that are really relevant to the topic of what we're talking about today, the Green Amendment movement. Chief Justice Castile wrote that by any responsible account, the exploitation of the Marcellus Shale Formation, the drilling and the fracking, will produce a detrimental effect on the environment, on the people, their children, and future generations. And that the natural resources that were being harmed were resources essential to life, to health, and to liberty. And that as a result, the provisions of Act 13 that we were challenging would in fact violate the Environmental Rights Amendment of the Pennsylvania Constitution. And so in that moment, with that victory, we defeated some of the most devastating aspects of Act 13 from ever going into play. And we defeated them before their devastating consequences could even start. But at the same time, we literally breathed legal life into that long ignored environmental rights amendment and restored to the people of Pennsylvania their constitutional right to clean air, pure water, to the preservation of the natural, scenic, historic, and aesthetic values of the environment. And we restored strength to the assertion and the recognition that Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. And that as trustee of these resources, the government officials of the Commonwealth of Pennsylvania must conserve and maintain them for the benefit of all the people, including those future generations. And so we overturned, again, that 42 years of bad precedent. We defeated those devastating aspects of Act 13, but we breathed legal life into that long ignored constitutional entitlement. Since that victory, many in industry and even in government said, well, Maya, that was only a plurality opinion. That didn't really change anything. Well, it did. It changed a lot. Because the plurality opinion, right, there was an additional justice that rendered a concurrence that didn't directly speak to Chief Justice Castile's environmental rights arguments, rested on another legal theory to support the determination that the provisions of Act 13 were problematic, but because they did not refute that plurality opinion had real, meaningful, powerful strength and really started to affect legal decision-making in the Commonwealth of Pennsylvania right away. But even for those naysayers and those doubters, very quickly, we started to get new decisions out of the Pennsylvania Supreme Court, mirroring, mimicking, and quoting Chief Justice Castile's language and making very, very clear that every single thing that he said about Pennsylvania's Article 1, Section 27 was, in fact, the majority opinion of the Pennsylvania Supreme Court. Now, in the wake of the victory, right, even before those additional precedents, but really in the wake of the victory, I really was reflecting in my role as the Delaware Riverkeeper of the power of what we had accomplished. And I recognized that we needed to have this kind of powerful constitutional entitlement in every single state constitution across our nation. And so I looked at the Pennsylvania amendment to identify what made it so important, what made it so powerful, and what made it so special. And Mel is going to share that with you.
So let's just start from the very beginning. Green Amendment is a term of art because, as Maya had talked about before, it sets it apart based on certain aspects from just general environmental rights that might appear in state constitutional provisions. But green amendments will help ensure its proper scope and effects take place as intended. The first criteria is that it needs to be placed in the Declaration of Rights or Bill of Rights section of a state constitution. This placement helps ensure that the fundamental nature of such rights triggers strict scrutiny review, which everyone should be familiar with. But to pass strict scrutiny, the government's action must further a compelling governmental interest and must have narrowly tailored the action to achieve that interest. So that's the basic standard. This by itself really provides the game-changing element to environmental protection to include clarifying legal priorities such as hierarchy of rights, which we can talk about later. But other aspects of green amendments include they recognize a human individual right of all people to a clean, safe, and healthy environment. Green amendments are also self-executing. They're ready on day one and do not need further legislative implementation or agency regulation to put it into effect. They include an enforceable cause of action to seek equitable relief, such as declaratory, injunctive, restorative remedies, as may be appropriate to the facts of the case. Green amendments protect elements of the natural environment that sustain life to include future generations, which embraces the precautionary principle or the prevention principle. Green amendments help answer the challenges of environmental justice, importantly, due to their fundamental and highest level of judicial treatments. They integrate a whole of government approach, address conflicts, and sometimes they include a trust framework to guide government policy and decision makers. So all of these attributes and criteria help address the shortfalls of the current system we discussed earlier, and so should be included and enshrined as constitutional amendments. So Maya will now talk about green amendments in the United States.
And, the long and the short of what happens when you have all of these critical elements is you very literally lift up environmental rights. So they are given the same highest constitutional standing as all those other fundamental rights that we hold dear, right? We all know how powerfully the right to free speech and freedom of religion are protected. Well, now environmental rights are given that same most powerful protection. We're not asking that they be treated better or that they be treated worse. We're asking actually that they be treated the same. And that's what a constitutional green amendment with all of these critical elements accomplishes. Having this list of criteria, this understanding of what made Pennsylvania's amendment so unique. I did actually go forth and look at every single state constitution across our nation. And I found that only Montana lifted up the environmental rights of the people of that state to that same highest constitutional standing as Pennsylvania did. There were a lot of other states that talked about the environment in their constitutions, but only Pennsylvania and Montana back in 2013 accomplished this highest constitutional protection. Having now begun the Green Amendment movement and embarking on the effort to really help communities across the nation seek and secure this highest constitutional recognition and protection, we actually have now also accomplished Green Amendment passage in the state of New York. So you now have this kind of Bill of Rights recognition and protection, self-executing in Pennsylvania, Montana, and as of voted in 2021, actually went into the Constitution January 1, 2022, have a green amendment in the state of New York. But there are also, and I'm not sure if this is the place that I'm supposed to say it or not, but I'm going to say it anyway. But we also have green amendment proposals that are advancing in 15 other states. And you're going to be hearing from Mel later about the powerful movement that is happening in the state of Florida, where they are advancing this kind of highest constitutional protection. But this is really a powerful pathway for transformational protection that instantly resonates with communities, with environmental justice communities, with lawyers who care about the environment, with progressive legislative leaders, with people of all kinds. We all understand what it means to have a constitutional right to something. And when people understand that they don't have that kind of protection for that basic fundamental right to clean water, clean air, a stable climate, and healthy environments, they are eager to remedy that oversight of history in their state, but also nationwide.
Great. So let's take a look at the wording of these provisions themselves in Pennsylvania, Montana, and New York. I'll go ahead I'll go ahead and read through because we're okay on time right now. In Pennsylvania, Section 27 provides that the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. And in Montana, again in the Declaration of Rights, all persons are born free and have certain inalienable rights. They include the right to a clean and healthful environment and the rights of pursuing life's basic necessities, enjoying and defending their lives and liberties, acquiring, possessing, and protecting property, and seeking their safety, health, and happiness in all lawful ways. In enjoying these rights, all persons recognize corresponding responsibilities. And finally, in New York, which we'll get into much more later, also in their Declaration of Rights, each person shall have a right to clean air and water and a healthful environment. So we can see that all three were placed in their respective constitutions' Declaration of Rights section. Check. Next, we can see that language points to the people, all persons, each person having a right to various aspects, sustainable aspects of the environment. We see intergenerational and trust language in Pennsylvania's and in provision. And in Montana, the first of their listed inalienable rights was the right to a clean and healthful environment, couched with other rights of life, liberty, and property. One quick note I just wanted to mention is that while New York's language is shorter and technically meets the basic criteria of green amendments, the more robust language has proven incredibly valuable, as we'll highlight in a bit. So let's go to the next slide.
Okay. And just before we do that, yeah, because the next slide, we're going to talk about some of the other states and do like a comparison. But I do just want to note here, and we didn't put it on the slide, right? Because you can only give so much, but,
right.
In Pennsylvania, as Mel said, in all three of these, you have that individual right component. Pennsylvania also has the trustee language and the generational language that we highlighted earlier on as being really critical for Green Amendment protections. It's not one of the essential must-have elements, but it really, as Mel said, has been proven incredibly valuable. In Montana, there's additional language lower down in the Constitution that in the Supreme Court rulings that you're going to hear about later, the court actually took this other really valuable protective language that's lower down in the Constitution and bootstrapped it up to help strengthen the interpretation of Article 2, Section 3. And so that has proven very valuable and beneficial. And so actually Montana's language is a bit more robust because of that lower down language and the way the courts have brought it up and brought it together. And that's where you'll find some of the other Green Amendment elements that we've talked about. Now, we did want to talk about some examples of other states to sort of talk through or demonstrate why these other states don't have green amendments. But writ large, the list, in the slides on the right sort of covers the universe of problems that we see. First off, we don't see the language in the Bill of Rights or the Declaration of Rights section of the Constitution. Sometimes we actually see some language in that section talking about the environment, but they're talking about things like the right to fish, hunt, and trap, for example. They're not talking about those essentials of life, like clean water and clean air. Or the right to navigate. They very clearly entrust the definition of the environmental right to the extent that it's talked about to the legislature. So taking away that self-executing nature of the amendment, taking away the mandate that all government officials at every level of government be constitutionally obligated to respect and protect those environmental rights in all aspects of government decision making. They often will declare the environmental entitlement that's promised in the language to be just a policy statement, right? That's what happened in Pennsylvania, but actually the court did it. They declared it to be just a statement of policy, robbing it of its strength. What I always say when I, do my talks to non-lawyers is, policy is good advice, and you can take it or you can leave it. Right. And that's what we tend to see when you might have language that sounds very beautiful about environmental rights, but once it's declared to be a policy, shoosh, it sort of all blows away and nobody seems to pay attention to it anymore. Often we will see the language focus on pollution prevention or pollution control rather than a right of the people to a clean, safe, and healthy environment and an obligation of government officials to protect natural resources for the benefit of the people as opposed to some sort of economic agenda. And they aren't crafted in a way that allows government officials to address those other fundamental failings like cumulative impacts and environmental racism. So those are writ large some of the problems that we see, but we see other things. They often aren't generational. Really, truthfully, all of them at this point don't talk about the climate specifically. These are things that we're trying to remedy with modern day Green Amendment proposals that are advancing in those 15 states that I noted but didn't name. So let's look at some examples. So this is Article 20, Section 21 of the New Mexico Constitution. It's located in the miscellaneous section of the Constitution, not the Bill of Rights. And it's titled Pollution Control, and it reads, the protection of the state's beautiful and healthful environment is hereby declared to be of fundamental importance to the public interest, health, safety, and general welfare. Well, that's lovely. But then it said the legislature shall provide for control of pollution and control of despoilment of the air, water, and other natural resources of the state, consistent with the use and development of these resources for the maximum benefit of the people, right? So the fundamental failings, it's not in the Bill of Rights section of the Constitution. It's in the miscellaneous section. It is focused on pollution control, control of the despoilment of the environment, but most notably, other than the miscellaneous section. The miscellaneous section is a huge problem. But in addition, it says the legislature shall provide. So actually, the constitutional entitlement of the people is that the legislators will legislate for the environment. And if they legislate badly, bummer for you. That the constitutional obligation has been fulfilled, but the people are no better off. And we actually see that in the one case that has been decided to date regarding Article 20, Section 21. There, the court, as we see in all of the constitutional claims around existing constitutional environmental language, the court looks first to the plain language of the amendment. And in this case, the court looked to the plain language and said, look, the obligation falls to the legislators. And if they get it wrong, the remedy that the people have is to vote better people into office so that their legislators get it right by the definition of the people. And so that really confirms, our reading that when it's up to the legislators to legislate, that's the entitlement. And that's what is the right of the people. It's not a right to clean water, clean air, a stable climate, and healthy environments. I do want to note that there was just a legal case filed in the state of New Mexico about 2 weeks ago, based on Article 20, Section 21, as well as some other constitutional claims trying to address issues having to do with fossil fuels and the climate. And so we'll have to see how that case plays out to see if there's any additional understandings of Article 20, Section 21 coming down the pike.
Awesome. So yeah, Florida's problem is also pretty simple, probably simpler than New Mexico, but the language was not just in the general provision section, definitely not in the Declaration of Rights of the Constitution, but it says it's a policy statement. So it's advice. It shall be the policy of the state to conserve and protect its natural resources and scenic beauty. Adequate provision shall be made by law for the abatement of air and water pollution and of excessive and unnecessary noise, and for the conservation and protection of natural resources. I will make a quick note that in 1980, the Florida Supreme Court did refer to a particular statutory cause of action provision as having created a substantive right and ability to enforce the citizens' right to a clean environment that they weren't afforded before. So there was a very slight mention of the existence of such a lofty right, but not much was developed after that. And in 1997, the Florida Supreme Court had noted that this section was mere policy and that it clearly directed the legislature to provide for the abatement of pollution. So there you go. And today we have thousands of dead manatee, millions of acres of seagrass just gone, lakes too polluted to swim in. And I think that Florida is like number one in the nation for that honor. 9,000 miles of rivers and streams too impaired with fecal bacteria, 1,000 springs impaired. Well, we have 1,000 springs. I think they're like 80% of them are too impaired due to excessive nitrogen. Harmful algal blooms are not just the new normal. They're continuing to become more frequent, more severe, and lasting much longer up and down both coastlines. And I could go on about Florida, but let's just say that the status quo and the current system of environmental laws have not worked, despite policy language right in the Constitution.
So Hawaii, we wanted to talk a little bit about Hawaii because a lot of people hear that Hawaii also has a Green Amendment. And in fact, Hawaii doesn't currently have a Green Amendment. There is a Green Amendment proposal, though, to remedy that. What Hawaii has is two provisions. One that has not proved so helpful and one that has proved really helpful. So let's just talk about the provision that people generally assume is a Green Amendment. Article 11, Section 9, which talks about environmental rights and talks about each person having a right to a clean and healthful environment. But we then get sort of that language of as defined by laws. So now, again, the power is given to the legislature to define what is the right to a clean and healthful environment. And so and case law has supported that it is the legislation that defines the entitlement. And so if the legislation doesn't do a good job, if it doesn't actually protect that human inalienable right of people to a clean, safe, and healthy environment, the people are kind of out of luck because the power lies with the legislature, the ultimate entitlement, and therefore power does not lie with the people. Now, people often hear, well, but Article 11, Section 9 has been deemed self-executing by the courts. And yes, it has been deemed self-executing, but the self-executing part is the right to enforce the laws that interpret, define, and seek to protect the environmental right. That's the self-executing part. The self-executing part is not the right to a clean and healthful environment. It is that second provision that any person may enforce this right against any party, public or private, through appropriate legal proceedings, subject to reasonable limitations and regulation as provided by law. There again, the limitation, the power is with the legislature, but what they may enforce in terms of the right are the laws. It's not the individual entitlement. And so that's where the confusion comes in. And so that's why Hawaii will benefit from and is seeking a constitutional right to a clean, safe, and healthy environment added to the Bill of Rights section of the Constitution, that individual right of the people. Now, what is very powerful and helpful, and what Hawaii does have, is they do have that trustee element, that we talked about being so powerful in the Commonwealth of Pennsylvania and being a really powerful element of the best green amendments that are advancing. Well, Hawaii already has really powerful trustee language located in Article 11, Section 1 of their Constitution. Right, that creates a trustee obligation of the state to protect the state's natural resources, including the land, the water, the air, the mineral, the energy resources, right, and to protect them for present and future generations. There you have that generational language. So this provision has proved really powerful and really helpful in protecting the natural resources of the state of Hawaii in many, many contexts. But there are some contexts where there has been tension between the natural resources protection and the individual rights. And so that sort of plays out a little bit differently. But we really want to acknowledge the benefit of that trustee language. And also do want to acknowledge that there have been some really powerful cases that have been filed and or decided, or at least decided at the motion level in the state of Hawaii, where they talk about both the Article 11, Section 1 and Article 11, Section 9. But even in those cases, while there's some really beautiful language coming out of the justices talking about both provisions, what we see is there's not a change in interpretation regarding Article 11, Section 9 being defined by the legislature and legislation, right? So a lot of these cases, actually, when you read them, the power is really coming out of Article 11, Section 1, and then you have a piece of state legislation implementing Article 11, Section 9 in a really meaningful way. And so then that combination of the law with the constitutional language provides that added oomph. But it's still not creating that individual entitlement that we see in other Bill of Rights provisions.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Note. N-O-T-E. Note.
So now let's see how green amendments brought beneficial change so far. And next slide, we'll just step through the 3 states where the green amendments have existed: Pennsylvania, Montana, and New York. And we'll notice how these cases, how the courts treat these provisions differently due to their fundamental nature, and how the benefits of green amendments play out pretty obviously. So back to you.
Great. So just doing a time check. So we're kind of going to go through these cases pretty quickly. So this Robinson Township, Delaware Riverkeeper Network v. Commonwealth, that's the Act 13 case, right? So just want to highlight, some of the things that Chief Justice Castile made clear in his beautiful language is that, like other fundamental entitlements, first and foremost, the environmental rights provision in the Bill of Rights section of the Pennsylvania Constitution is a limitation on government authority. It's not a grant of new authority. Chief Justice Castile talked a lot about the trustee obligation and how that's not just the public trust doctrine. This is really bringing to bear the full breadth of trustee law that exists within a state, and creating and does, amongst other things, create a fiduciary obligation or obligations of prudence, impartiality, and loyalty. So there's an obligation for informed decision making, for making sure that all beneficiaries, all the people, regardless of race, ethnicity, socioeconomics, right, are being given the same level of protection when it comes to their natural resources. That it is the people who are the priority, not the profit making of the corporations that might be getting impacted. He was very clear about the self-executing nature of the amendment and that it applies to all government officials. And that was one of the things that benefited the local municipalities. The state could not preempt and usurp, take away, or not. It's not that they couldn't preempt or usurp. The state could not mandate that local municipalities allow fracking to be happening in these devastating places and ways, because they would then be mandating that the municipalities violate the environmental rights and of the people and the Environmental Rights Amendment in the Pennsylvania Constitution. And really made clear that, the kinds of remedies that we're talking about here are things like declaratory relief, and those kinds of remedies can be meaningful. So the outcome of the Act 13 case were that the problematic provisions were struck from the law as being unconstitutional. We didn't see, like money payouts. We then had, we've had a series of cases in the Commonwealth of Pennsylvania brought by the Pennsylvania Environmental Defense Fund or Foundation, which have been really focused on how to utilize income from leasing of public natural lands within the Commonwealth of Pennsylvania. When lands were leased out for fracking, right? So the natural resources were being extracted for money in leasing, what could happen with that money? This is a very complicated series and set of cases, so I'm not going to go into it. But we did just want to pull, one of the cases. The other earlier cases reinforce everything that Chief Justice Castile said in that Act 13 case. But in 2021, one of the series of this case is really focused on the generational component of the Green Amendment in the Commonwealth of Pennsylvania, and really stressed that it means what it says. Future generations have a right to the healthy natural resources, and for the natural resources of the state to be protected as powerfully for them, for future generations, as it must be protected for present generations. And so really, putting an exclamation point, on the point that it's not just pretty rhetoric to say that future generations have a right to healthy natural resources, to a healthy environment. It actually is substantive and meaningful and enforceable. And I think that that's just, to me, what's so important about that case. And then we've also had a very recent case that just came out a few months ago, talking about an LNG transfer station. And that was being challenged by a local municipality. Again, many iterations to this, but for this particular opinion, I think what we wanted to pull out was that here we had the Public Utility Commission looking at this LNG transfer station in the community of Marple, and the community of Marple saying, look, it's going to have environmental implications. And you, Public Utility Commission, by virtue of Article 1, Section 27 of the Pennsylvania Constitution, have to think about the environmental impacts on our community. And the PUC kind of said, no, we don't. That's DEP's job. So they're handling that. And the court came back and said, no, you can't do that. All government officials in the Commonwealth are constitutionally bound to consider and protect the environmental rights of the people and the natural resources for present and future generations. And that means that you can't just pawn it off on some other agency. The PUC can be mindful of, can take into consideration, can think about, can talk about what the Department of Environmental Protection has to say about this, but they really have to do their own constitutional consideration of the environmental rights and the environmental impacts in order to fulfill their constitutional duty as defined by Article 1, Section 27 in the Pennsylvania Constitution.
Okay, all righty. So let's take a look at Montana now. In the early 90s, there was a mining permit that wanted to pump underground water at the proposed mining site. The Montana Environmental Information Center, along with Clark Fork Penn ORAE Coalition and Women's Voices for the Earth, challenged the exploration license, saying that the Department of Environmental Quality had illegally allowed by permit groundwater, surface water, and the aquifers of the Blackfoot River and Landers Fork River to be contaminated with arsenic and zinc, and that the agency failed in its obligation pursuant to state law that there would be no degradation of water quality, and that any waiver of the non-degradation policy would violate Montana's Constitution. So after being dismissed, the organizations appealed to the Montana Supreme Court, and so in 1999, this was, I believe, the first time the High Court reviewed these environmental rights provisions from the Constitution. There were a few important takeaways from the courts of opinion. First, that the right to clean and healthful environment is a fundamental right, basically because it was set forth in its Declaration of Rights, the surrounding terminology. So because of this, the court applied strict scrutiny, where government action may only infringe upon an individual's fundamental constitutional right if there is a compelling state interest for doing so. And also that infringement must be as slight as possible while still furthering the state objective. So courts could no longer merely trust that the legislative or administrative determination that infringement of this right was justified. They now had a duty to inquire into the justification for and impact of the infringement. One more takeaway from this case is that the protected provisions are preventive and anticipatory in nature, no longer requiring, for example, significant environmental impact or some demonstrable threat to public health before the right to clean and healthful environment is implicated. The court stated, our Constitution does not require that dead fish float. I love this quote. Does not require that dead fish float on the surface of our state's rivers and streams before its far-sighted environmental protections can be invoked, which is beautiful. So with this case, Montana's Green Amendment started taking effect. Next case is Cape Francis Enterprise. So a couple years later from the previous case, the court looked at whether the performance of a contract provision between two private parties would violate the constitutional environmental right. Cape France Enterprises owned a tract of land in Bozeman, Montana, a part of which Lola Peed and her granddaughter wanted to buy to build a motel hotel type of structure, but it needed to be subdivided first and rezoned first. So this triggered the need to demonstrate that a water source existed, which required the drilling of a new water well. Unfortunately, there was a pollution plume in the neighborhood, just too close, that was spreading in the groundwater nearby, and drilling the well could cause the pollution to expand and contaminate additional groundwater aquifers with such chemicals as perchloroethylene or PCE, which can cause cancer, dysfunction of the liver and kidneys, long-term issues with nervous systems, and it's toxic to aquatic life. So there was significant potential economic consequence of drilling the well, which Cape France did not want to embrace or be on the hook for. So so it really wanted to be relieved of this contractual obligation of drilling the well. So that's what was at issue. The court confirmed that the constitutional mandate of maintaining and improving a clean and healthful environment for present and future generations applied to both state actions and private action, and private parties as well. So the court went on to say that the specific performance of this contractual provision would be unconstitutional. Quote, for a court to mandate specific performance of the contracted issue on the record here would not only be to require a private party to violate the Constitution, a remedy that no court can provide, but as well would involve the state itself in violating the public's Article 2, Section 3 fundamental rights to a clean and healthful environment, and in failing to maintain and improve a clean and healthful environment as required by Article 9, Section 1. So in terms of contract law, it would amount to be an illegal, unconstitutional provision. All right, so moving on to a more recent case in 2020, the Montana Supreme Court looked at the environmental implications of industrial mining exploration activities and the fact that a 2011 legislative amendment to the Montana Environmental Policy Act, or MEPA, had disallowed a court from stopping work on a project even when it determined inadequate environmental impact analysis occurred. So the challengers claim that the 2011 amendment prevented the courts from protecting constitutional environmental rights in the Montana Constitution, which would of course be unconstitutional itself. The district court found that the state agency had in fact failed, and they admitted to, undertake robust environmental analysis required under the MEPA, and that by prohibiting the court from rendering equitable remedy, the 2011 amendment had caused an unconstitutional violation of the plaintiff's environmental rights. The district court remanded the project back to the state agency for the required MEPA review and voided the mining exploration license of Lucky Minerals, who then appealed to the state Supreme Court. So in 2020, the Montana Supreme Court issued an important ruling that further strengthened the Montana Green Amendment and affirmed the state's affirmative obligation to protect the environmental rights of the people. So these are a few bullets that highlight the takeaways, and I'll highlight the last point that decision makers have an anticipatory and preventive constitutional obligation. The cost of state error in failing to conduct the required environmental assessment would come at the expense of the environmental rights of the people. And I just wanted to very quickly quote something that the court quoted, which is from a delegate from the 1972 convention, May Nan Robinson, that, quote, a remedy implemented only after a violation is a hollow vindication of constitutional rights if a potentially irreversible harm has already occurred. The Supreme Court had also found that the 2011 amendment failed under strict scrutiny and held it to be on its face unconstitutional. So the lower court's order to vacate the mining license was upheld. All right, let's talk about held.